All right, to get the show on the road, as introduced, I'm Kiamakhetsi Motloghelwa, and I will be presenting with my supervisor, Dr. Phemelo Magau, and the title of our paper is Rethinking the Role of Equality in Access to Debt Relief Measures for Poor and Low-Income Earners in South Africa. Next slide, please. I'd first of all like to start by highlighting that our research article was supported by the NRF, the National Research Foundation of South Africa, grant number 141993, and the UK Zedin School of Law. We'd like to thank them as they in part sponsored our travel arrangements to be at this conference. Now to get into the simpler aspects of our paper, I will start by doing the introductory remarks paper, which is the role of equality on statutory debt relief measures in South Africa. We will then proceed to discussing the various statutory frameworks that provide these debt relief measures, and then we will conclude this paper. Next slide, please. So this paper is a work in progress, so questions, answers during that session, we do very much appreciate your input and highlights into how we can better develop this paper. Basically, our paper seeks to provide a background really on the importance of equal debt relief measures in South Africa, because we're faced with a situation where debt relief measures are not equal on different classes of citizens in South Africa, where they're more accessible to others than they are to poor and low income earners. We'll further discuss the role of equality in accessing debt relief measures. This is where really we're trying to rethink how we can get the Constitution to have a bigger role in trying to provide better debt relief measures to all of financial consumers in South Africa. We then discuss the various ways in which debt relief measures can be effected, and this is mainly done to show really and highlight the inequalities in the provision of debt relief measures, and really highlight how different classes of financial consumers might not qualify for these debt relief measures. We then discuss the various provisions the regulatory statutory frameworks which provide these debt relief measures. In South Africa, debt relief measures are provided by the Insolvency Act, the Magistrate Courts Act, and the National Credit Act. Now, just to define our key terms so that we're on the same page going forward and there's no confusion in that regard, we basically define equality as a constitutionally enshrined right, that advocates for the state of being equal, especially in status, rights, and opportunities. This is very relevant going forward in understanding why we say there needs to be equality in the provision of debt relief measures. Our debt relief measures entail the process of rearranging or reorganizing outstanding debt in order to provide financial consumers with relief in relation to the debts that they have and repaying the debts that they have to their creditors. Our low-income earners refer to indigent debtors. These are the poor. These are the people who really have little to no income, with a limited disposable income who have few assets. Next slide. I will now get into the importance of debt relief measures. Before we get into that, we first need to understand how debt relief measures can be effected. This is possible in various ways. We could either relax the terms and conditions of a debt to allow financial consumers more breathing room. We could, or rather they provide for partial or total remission of debt or mitigation of outstanding principal debt. Basically, this is done to afford financial consumers, especially poor and low income earners, to be able to clear their debts and to be able to continue on without the burden of over-indebtedness. Another importance of debt relief measures relates to really understanding why they're important. And this is because they lead to the promotion of socio-economic welfare of South African households. This means that debt relief measures are important in that when they are available, financial consumers who were previously over-indebted are provided the opportunity to move forward with their lives debt-free, thus overcoming various challenges such as poverty, such as being unable to afford a proper education, and similar instances. Debt relief measures that are equally accessible to financial consumers are crucial in that they assist our indigent and low-income earners to manage and improve their financial standing. And like I just said now, when your financial position is in a better state, you're able to be integrated into the economy and contribute really and be a player in the financial sector of your country. Now, equal accessible debt relief measures are pertinent in assisting low-income earners to be integrated into economic activities by ensuring that they're treated fairly and they're not biased based on their financial positions. Now I hand over to my co-presenter to really get into the nitty-gritty of it. Thank you.
Thank you, Kiamu. The next slide, all right. The next slide deals with in accessing debt relief measures, which is where, like Kiamu was saying, we are trying to rethink really what really the role of equality could be and the Constitution in this regard. Equality, of course, is one of the founding values of our constitutionalism in South Africa. It is one of the 3 founding values. It is also enshrined there in the Bill of Rights, Section 1 and Section 9 of the Constitution. That's where you'll find equality in the South African Constitution. The principle of equality now, in the context of debt relief, it merely speaks about ensuring that the poor, the low-income earners, they are treated equally. Those who do not have assets, those who do not have enough money, they are treated equally in ensuring that they are able to extract themselves from their indebtedness. So that is why equality is then important in this regard. So, and it has become quite important, equality, because we have abject poverty in South Africa. We have the challenge of over-indebtedness in South Africa. Of course, there are many challenges which lead to over-indebtedness, such as reckless credit granting, the lack of adequate financial education. But that being the challenge, debt relief is also not equally accessed, which is what we are trying to argue for in our presentation, that equality in debt relief, in the debt relief regime, could assist in promoting a sustainable and efficient as well as an accessible credit market. Because in South Africa, we are trying to move, or we are just coming from a dispensation where most poor and low-income earners were not really allowed or could not really access credit adequately. So now we are trying to ensure that they are able to participate equally into the financial into the financial sector, as well as into the economic activities of the republic in general. Now, there are 3 pieces of legislation which regulate debt relief measures in South Africa. The first one, of course, it is the Insolvency Act. Your Section 3 up until Section 12 of the Insolvency Act. This is the one that deals with sequestration proceedings. Sequestration proceedings can be effected in 3 ways, either through voluntary sequestration or through compulsory sequestration, or the third one being friendly sequestration. So now, the underlying requirements in order for one to be successfully sequestrated is that they need to prove an advantage to the creditors. And in order for one to prove that there will be an advantage to creditors if they're sequestrated, they need to do so by showing that they have assets, which after they have been sold, the proceeds from the sequestration proceedings will then be used to pay off the creditors. So if you do not have assets, if you do not have enough money, assets that can be sold so that we can pay off the creditors, it means that automatically you are excluded from utilizing sequestration proceedings. And as such, it means you cannot then access debt relief through sequestration proceedings. So this differentiation between those who have and those who do not have, it is what we are trying to argue against. That perhaps maybe, as we'll come to the recommendations, how about we relax this requirement, because currently it is applied rigidly so, without really any due regard being given to the poor and low income earners. The second debt relief measure, it is regulated by the Magistrates Courts Act, and here we are talking about Administration Order, Section 74 of the Magistrates Courts Act. In terms of this provision, an administration order really, it does not offer any discharge to the consumer, but it's a mere rearrangement plan of how your debts can be paid off. So, but another disadvantage that we have under the administration order is that your debts, it has a monetary ceiling or a monetary cap of 50,000 rands, that your debts, cumulatively, your debts must not exceed 50,000 rands in order for you to use Magistrates Courts Act administration order. So if your debt